Hello. Yes, it is me, Dr. Michael Arnheim. I know you won't recognize me under all this fuzz. That is the fault of the coronavirus. Now, this series of videos is called Know Your Rights. Know Your Rights. And today I just want to give you a little introduction to that. You know, quite a long time ago in the 19th century, a judge said, "The law courts are open to all, just like the Ritz Hotel." And of course, that is ironic because the Ritz Hotel is open to all in the sense that anyone can just walk in and take a seat and order a cup of tea or something. But if they want to stay the night, it's going to cost them a lot of money. Even to have a decent tea probably be quite expensive. So what this judge actually meant is that the law courts are not really open to all because it's an expensive business to go to court. And the situation has not improved in the 150 years since that was first said. So my first and most important piece of advice to everyone is try to keep out of court. Try to keep out of court. As they say in America, when you go to court, you're rolling the dice. Unfortunately, the position in Britain is even worse because this is one of the few countries in the world where you can go to court on a dispute worth £10,000 and you can end up paying £100,000. You can end up losing your house, your livelihood, everything. Now, why is that different from anywhere else? Well, a couple of reasons. One of which is that we have these two professions, solicitors and barristers, and people normally think that they have to go first to a solicitor and then to a barrister if need be. That's actually completely wrong. And since 2004, you could come directly to a barrister. You still can. It's amazing how few people know that. But let me repeat it. Since 2004, you can come directly to a barrister. You don't need to consult any other kind of lawyer. You can come directly to a barrister. And that includes pretty well any kind of law. Whatever your issue is, that will apply. But the barrister you go to will have to be registered for what is called public access. So there is that. The second main reason is that this country is one of the few jurisdictions, we say, it's one of the few jurisdictions where the loser has to pay the winner's costs. That is not the case, for example, in America. And even where it is the case, like, for example, in Germany, the system is set up in such a way that the costs are not going to be exorbitant. Germany has a system of inverse proportion to the value of the claim, so that a small claim will cost proportionately more than a big claim. I mean, for example, you start with 20% for a very small claim. You may have to pay 20% of the value of the claim if you lose the case. But then as the value of the case increases, so the percentage of costs that you would have to pay decreases. It's an inverse proportion, and the top proportion is 2%. You will never have to pay more than 2% of the value of the claim. I have tried to encourage the authorities in this jurisdiction to adopt the German system of costs, but so far to no avail. There have been some reforms of the cost system in the past few years, in particular in regard to personal injury, and especially the introduction of the no-win, no-fee arrangement, which is a bit of a misnomer, really. It's not really that, but is properly called conditional fee agreement, and there are a few other reforms that have been introduced. But essentially and in general, the system remains one in which the loser pays the winner's costs, and although there are some controls over the amount, it is still a very potentially dangerous system to get involved in. So those are the two main reasons why you should stay out of court. Now, obviously, if someone sues you, you can't stay out of court. Well, you can eventually if it's settled, but initially you may have to be dragged to court. And the other situation where you may be dragged to court against your will is criminal law. If you're arrested and you're charged with a crime, that's a whole different ballgame. But in general, there's no need for you to go to court, and you should try to avoid it as much as possible. So how do you do that? Well, first of all, if you are engaged in a contractual dispute, a dispute with someone over money, whether you've bought something from them, whether you've sold something to them, whether it's a service you've performed or whether it's a service you've received or supposed to have received, those are all contracts. And many, many disputes arise out of contracts. And the way to avoid contractual disputes going to court is by having a written contract in advance. It costs a little bit of money to have that, but it really is worth it. A written contract is very, very necessary. Sam Goldwyn, the American movie mogul, used to say, an oral contract isn't worth the paper it's written on. I think what he meant was an oral contract is not worth the paper it's not written on. You must have a written contract. If the case is about tort, that is a civil wrong, most civil cases are tort cases, whether it's a motor accident, an accident at work, or anything of that nature, many, many different varieties of tort. Those cases are very tricky, and even one of the most senior judges in this country has admitted that the law of tort is not based on any principle, which is very, very worrying, because the point about having a principle-based law is that it is predictable, and that means it is more likely to be just. Justice depends on predictability, and predictability depends on having principles that are known. So that's another serious problem. It's a serious area, more difficult area to avoid litigation. That means going to court. It's more difficult to avoid that in tort than in contract, but it should be avoided there too. And one of the commonest areas of tort is what we call vicarious liability. That means where you are liable for the wrongdoing of someone else. Now, how could that arise? Well, it arises all the time, actually, mostly in regard to employment. If you are a bus driver, for example, and you are guilty of killing someone on the road, that normally will be a case of vicarious liability. You, as an individual, will not normally be held liable, but your employer will be. Of course, there may be cases where you're drunk or you've gone completely off the rails, and so you may be, in fact, guilty of a crime as well. But normally, if you are responsible, if you are the cause of someone else's injury on the road, at work, or something of that nature, normally this will be a case of vicarious liability where the employer takes the rap for his employee. But again, it's a very tricky area of law, unfortunately. As for crime, well, that is a whole different ball game, as I said. And if you are arrested, then you will most certainly need a lawyer. There normally are duty solicitors attached to the police stations. Those are not always the best people to have on your side, because they're not always very helpful, unfortunately. Some are very good. Some are very good, but not all. So therefore, beware. If you are arrested, what you should do is try to find a lawyer that you can trust, and make sure that you never attend an interview without a lawyer being present. Well, that's all for now, and as I said, this is only the first of a series of talks.